All right, hello and welcome to Win Without Law School. I'm Arizona lawyer Julie Lebenz, and today I want to talk about objections in the context of procedure. How do you make an objection? Let me see if I can change this. How do you make an objection? When do you make an objection? There we go. And how does that work? So let's talk about trial procedure, which we've covered a couple of times now, and hopefully you're getting really familiar with this and have it, top of mind, which is we start with opening statements. Now, you really aren't going to object during the other side's opening statement. It's possible if they're going on and on or they're getting into argument, you can object, but in general, an opening statement sometimes gets waived. It doesn't even happen. Other times it's just a few sentences. It's really short. In family law cases, the amount of court time you have is so limited that in general, you're not spending a lot of time on opening statements. So for the most part, there aren't going to be any objections during opening statements. The only potential objection is, objection argument, if they're starting to get into arguing their case, but honestly, usually just let them finish, let it end, move on is generally the best approach as far as potentially objecting during opening statements. Next, we have direct examination. So the petitioning party calls their first witness to the stand. It could be them themselves. Let's say it is. So the petitioning party, let's say, takes the stand and starts to testify. Now, if they have an attorney, then their attorney is going to be asking them questions. And if you're the responding party, this is when you have the opportunity to object, which is right after a question is asked. You can pop in objection. So, for example, let's say that it's a parenting plan modification trial, and the opposing attorney starts asking questions about property that was divided in the divorce decree. So clearly, a question about property is not relevant to a case about modifying parenting time. So if the attorney asks the first witness, tell me about what happened with property under your divorce decree. Objection, relevance. Okay, so right when the question is asked, right when they're done asking it, that's when the objection is to be made. Certainly the witness could start giving their answer before you get the objection out. But in that event, you say objection, you need to move on this quickly. You can't have the witness say their whole answer and then object because it's already on the record now. It's too late for the objection. So the objection needs to be made after the question's asked, but it's okay if the person testifying starts answering and you make the objection just because there wasn't sufficient time to object before they started answering. When you say objection, you're going to need to explain what the basis of your objection is. So relevance, cumulative, those are some examples. We'll talk about that more in the next video. But for the most part, just keep in mind that when an objection is made, you need to explain the basis of it. And you can give some argument, So I gave the example of asking about property when parenting time is at issue. And so objection, relevance. They're asking a question about property, which is not relevant to parenting time, which is at issue in this case. At that point, and sometimes you can just say objection, relevance. You don't necessarily have to explain it, but sometimes the judge won't get where you're coming from and will want an explanation about what you mean. What do you mean this is irrelevant? So sometimes you will need to explain what you mean. Once that's done, the judge will turn to the other side and let them give their position on whether or not it's a valid objection. So if the objection is to relevance, this is where the other side would get to explain why it is relevant from their perspective. And then you, as the party that made the objection, the judge could potentially turn to you and give you one final chance to address whatever the other side just said. and then the judge will rule on the objection. So when the judge rules on the objection, it's either overruled or sustained. So it's obviously good to be familiar with those terms so you understand what just happened. So objection overruled, that means the judge believes the question is relevant and the witness now gets to answer. But if it's objection and the judge sustains the objection, then the judge agrees it's irrelevant, and now the witness is barred from answering the question, and a new question needs to be asked. So again, we're in this part of the trial procedure. Opening statements are done. The petitioning party has called their first witness. That first witness is on direct examination. They have a lawyer. The lawyer's asking questions. After the lawyer asks a question, that's when you can make an objection if there's an objection to be made. Now, let's say the petitioning party does not have a lawyer and they take the stand and they just start testifying. Since there is nobody there to question them, you're not going to be able to make an objection after a question's been asked because no questions are being asked. So instead, as the party is testifying, if they testify to something that is irrelevant or cumulative, for example, you just object after they've said it. So it's a bit weird as far as trial procedure goes, but technically, because there's no question being asked and you don't know what they're going to say next, that is your time to object. Once the petitioning party is done with their direct examination, then they're put on cross-examination. So let's say you're the petitioning party, and there's a different, witness testifying, you're not on the stand, and the other side's doing cross-examination. You would get to object after a question is asked. So you were ordered to sell the house upon entry of your divorce decree, correct? Objection, relevance. So again, once the question is asked on cross, that's when you can make your objection. You want to be cognizant and wait until the question is done being asked before you make your objection, because if you start talking over the party asking the question, the judge doesn't really like that. The judge can't hear exactly what's being said, and the questioner is entitled to ask their full question, and then you can object once the question is done being asked. So it's a real big pet peeve of judges if a person asking a question, or either a self-represented party or an attorney, interrupts and talks over a witness or the other side, because it messes up the record. Everything's being recorded. And if two people are talking at once, you can't tell what's being said or who's talking. So judges want the record to be crystal clear, and they don't want anybody talking over each other. So you want to obviously stay in the good graces of the judge. And as a result, make sure that you're not cutting people off, but instead letting it finish and then talk. Now, of course, I just said earlier, if you make your objection and the witness testifying has already started answering, it's okay to speak over them. You just didn't have enough time to make the objection. But you're not going to be able to allow them to start answering and then all of a sudden, break in with an objection. It'll be too late. Now, there, of course, are always exceptions. I have made an objection when somebody's going on and on and on and on, because there is an objection called non-responsive. If a question is asked, for example, what is your name? And I say, oh, my name's Julie LeBenz. I was born in Arizona, and I have a sister, and I have a cat. Well, all of those things other than my name are non-responsive to the question that was actually asked. And so if a witness starts going on and now they're testifying to stuff that wasn't even part of the question, you can interrupt them. Objection, Your Honor, non-responsive. So, there's all this courtroom etiquette. And I think that is just really what you want to be cognizant of, is coming across as professional and courteous. Because, of course, you can speak over somebody and make an objection and still be courteous. and obviously not do it repeatedly, and listen to any instructions the judge is giving you and still be okay, versus just not listening to what the judge is instructing you to do and repeatedly cutting people off. And, that's stuff that I think is pretty obvious is not going to work out as well as being kind and courteous and smiling. And we had a question here about, could you raise your hand? What is the objection concerning whether someone has the expertise to answer a question? Okay, so I'll answer that in a bit. But can you raise your hand? You can. Just, that raising your hand is not objection. So if this is in the context of a trial, a question's been asked, you can't just raise your hand because the witness is going to answer. So you do need to say objection. But I've raised my hand at times when, let's say there's an opposing attorney and they start going on and on and on with some sort of argument, and they're saying stuff that I want to respond to, and I'm wanting them to stop talking. I will sometimes raise my hand so the judge, to sometimes signal to the judge, okay, let's move on to what I want to say. And sometimes the judge is like, okay, Mr. or Mrs. So-and-so, I hear you. I'd like to hear from Ms. LeBenz now. So I will sometimes raise my hand to let the judge know, hey, I have something to say about this in response to what opposing counsel is arguing, but I wouldn't do that in the context of testimony. Instead, I need to orally object and make that objection. And so then the other question was, what is the objection concerning whether someone has the expertise to answer a question? So it would be to their knowledge. So whether or not they have the knowledge to testify to what they're talking about. So lacks personal knowledge, that would be, it's often called hearsay. There's a lot of exceptions to hearsay in family law, but any witness is supposed to have knowledge about what they're talking about. Whether they heard it from somebody else or read it somewhere, that's where some of the hearsay stuff can come on, but still they should have some sort of knowledge. And so if somebody's saying, I'm an expert, but then you start asking them questions and they have no education, no background, no experience, no reason to claim to be an expert, you can prove that through the questions. And then you could say, Judge, I move to strike their testimony because clearly they do not qualify as an expert witness. But that all gets a bit technical. In most cases, there is not going to be an expert witness involved. There could be, of course, an evaluator or something like that. But, really you're wanting to look at what are you trying to prove? And can you prove that through an objection based on relevance or something similar? Or is it through cross-examination where you can ask questions to prove the point you want to make? So, objection lacks qualifications. That could come up, on direct examination when the person is giving some background, objection, this person is not an expert, because when you have an expert involved, the attorney questioning the expert will lay all this foundation to show that they're an expert. And then at some point, the attorney will turn to the judge and say, I move to have this witness recognized as an expert. And then that's when there's an acknowledgement that this person, that there's been sufficient testimony and evidence presented to show, yeah, this person does have specialized knowledge on this certain point. So when the other side, moved to have them recognized as an expert, objection, no, they didn't show that they have any background in therapy and they don't have this education or that. That's a point when an objection to their qualifications could be raised. If a trial is virtual, we do not have to file a motion for one of them to testify virtually, correct? Yeah, I mean, if the trial is virtual, then in the order setting the trial, there should be, or there could be some language indicating, look, this is how you're ordered to appear. Everyone is ordered to appear this certain way. And so that's how your witnesses would appear as well. is by whatever's ordered in that order setting the trial, that's how they would appear. So if it sets a Zoom link or something, and then if it's an in-person trial, it says, hey, come to this courtroom at this time. So if you have a virtual trial, there should be an order to appear virtually, and that's how witnesses would appear as well. Okay, foundation objection then. Yeah, I mean, lax foundation is generally applies to an exhibit. But as far as a expert goes, I think it's the same sort of concept as far as lax foundation, but I don't know if that's really the proper terminology to use in the context. I would more be saying, does not qualify as an expert. They don't lack foundation as an expert. Of course, you could say it that way, and I think the judge would get what you're talking about. But I think the more proper language is to say, no, they do not qualify as an expert. Okay, so I want to get back to the trial procedure. So we talked about opening statements. We talked about the petitioning party calling their first witness. We talked about how to make objections if the petitioning party is their first witness, and if they have an attorney or if they're representing themselves. We talked about cross-examination and making objections. Same thing if on redirect, again, you'd make an objection either after the question is asked, right after it, or if the testified party doesn't have an attorney and they're the petitioning party, then as they're testifying, you can make objections. That's going to be the same procedure with each witness. Okay, so when the question is asked, making the objection, or if the person is representing themselves, then making the objection during their testimony. So that's going to apply through, so the opposing party, they'll present their witnesses, same thing. If there's any rebuttal witnesses, same thing. And then we get to closing arguments. Generally, no objections will be made on closing arguments. I have made objections on closing arguments here and there. I usually get a bit admonished for it. It's not the best practice. Sometimes there's just been such outrageous things being said, I couldn't help myself and I objected. But for the most part, closing argument is an argument. And so there's a lot of leeway as far as what you can say and argue. And typically you're not supposed to object. You're supposed to give the other side their opportunity to present their case, on closing argument. So generally there aren't going to be any objections on closing argument. And then that's the end of the trial. So that's procedurally how objections will come up in a trial context. I'm going to end this recording for today. Thank you so much for joining us.